May I pray, my lord? The mention matter may kindly be taken 50 onwards, so we can take our chance at least. Mention matters on 50 onwards, lordship may kindly take a note, so we'll take our chance, my lord. Lordship usually taking after 100, so I pray 50 onwards, if a lordship will permit, it will be a list will be prepared.
Give a list, no, don't make a mention, just give the list.
Oblige, my lord.
My lord, item 130.
No, please give a list. I just told you. Just one list, everybody may give the
Pardon to mention, my lord.
be after 50. Mr. Sahu, it should be after 50 as he suggested. Okay.
So, honorable
Memo to mention, my lord.
So,
Mention is not chassis, my lord. Subsequently added 3-9. I had given a memo. No, next week, my lord.
It comes here, my lord.
Well, no, fresh item matter, my lord.
113. जो 64 को जी हाँ
Yes, madam.
My lord, item 82 may kindly be taken up today.
Just a minute.
Pardon to mention, my lord.
बेनिफिट 296 पे 2023 से मॉडिफिकेशन ऑर्डर थिला आपण आर शुक्रवार न कहितले ए शुक्रवार आसिया पे
अच्छा, asini list.
नहीं सर
It will come next Friday. Okay. We'll ask that why it has not been.
Sahoo or 80
ये mention को virtual mode है. हाँ, लिख लीजिए. Okay.
69, my lord. Pardon to mention, my lord. Item number 69, my lord.
We have noted. It has been noted. It will.
My lord, item 82.
It is also noted, madam.
Okay, thank you.
All the matters.
Supplemental list, item number 1.
May I please, my lord? I am appearing for
kindly take 87, item 87.
Perhaps you have not heard what I have said, that you are to give the number in a list, and that list is to be handed over to the State Council.
Yes,
Yes.
yes, madam.
Mr. Tripathi, and so the Land Council who have given their
you will supply, I will
please obtain that. Yes.
Item 2.
Last of all, also directed to produce the custodial certificate.
Yes, Mr. Tripathi.
yes, and 5 years, 4 days.
5 years.
Please pass on that. Should be on record.
Yes, sir. The possible.
What is the sentence imposed Land Council
10 years, madam.
for the offense under section?
376.
Okay. Have you ever been released on interim bail?
This is my third application. Previously, 2 times he has been.
When you were released on interim bail last time?
First application on 8/8/8.
No, I'm telling you about the last time.
Last order 3/5/2023.
3/5/23. You are released for 3 months.
Yes, madam.
Right.
Sorry, madam. On 17/10/2023.
So twice you have been released on interim.
Yes, madam.
Anything adverse against him, Mr. Tripathi?
No, Miller.
Okay. The Land Council for the IN number 414 of 2024 is an application for bail. Land Council for the petitioner submitted that twice the petitioner has been granted interim bail, each time for a period of 3 months, by order dated 3/5/2023 and 17/10/2023, and he surrendered at right time, and he has never misutilized his liberty. He further submits, out of 10 years of substantive sentence imposed by the Land Trial Court, the petitioner has already undergone half of the substantive sentence, and the paper book has not been prepared, and therefore there is no chance of early hearing, and the bail application may be favorably considered. Land Council for the petitioner, state has filed the custody certificate, which is taken on record, which indicates that the petitioner has undergone so and so category 5 वर्ष के तमास. The Land Council for the state also on instruction submitted that there is no adverse report against the petitioner during the period of interim bail. Considering the submission, period of detention in judicial custody, since the petitioner has not misutilized his liberty while on interim bail granted by this court twice, I am inclined to release him on bail. It is full bail. Okay. Yes, bail allowed.
Item number 3.
Well, may it please, Your Lordship.
Yes.
You must kindly see, my lords, the last order, which Your Lordships passed on 19th of July.
Mr. Sarthar.
Yes, Your Lordship.
Yes, the last order on
19th July, my lord. This was regarding that filing of 3 bail applications
during
pendency of the one.
Bail application and special public submitted that while these 3 bail applications were sub judice before this court, the petitioner
has filed another bail application so and so, wherein a wrong certificate has been made. The earlier application so and so have been disposed of by order dated so and so. And then Your Lordships had called for the file. Your Lordship now see that bail application 11625 minutes. My lords have it.
Yes.
Lord, there is definitely a mistake. Kindly see, my lord, what is the certificate?
11625.
Yeah.
The matter out of which this application is also connected with so and so. No, just a minute. I'm sorry. 625. My lords have it. Last order of 19.7. My lord, I have filed an affidavit where I have quoted it. Okay. Your lordship may see page 2, my lord. The certificate. Yes. The matter out of which this bail application is also connected with so and so. There are 3 bail applications. Right. As per, and the word is disposed of. That Mr. Naik said that is a wrong. He is right. I don't dispute. Okay. Disposed of. Now kindly see first paragraph. The petitioner in this instant case had been granted interim bail for a period of 6 months, subject to deposit of so and so. So he says there was an interim bail. So therefore, minutes. On 16/11, he was granted interim bail. That is said here. Now, if your lordship sees, I have filed an affidavit today. There, your lordship will see, my lords. One second. Now, my lord, there was a memo filed thereafter. In this case, on 18th February 2022. Kindly note the date, my lord. Your lordships have it. Which page? This, I'm holding this affidavit. Your lordship may see page 8. Page 8. So this bail application was filed on 30/12/2021. And there was a memo filed for withdrawal on 18th February 2012. 2021. Sorry, 2022. Lordships have it, minutes. Now he says petitioner doesn't want to proceed further, permitted to withdraw. Now, if your lordships kindly now turns to page 11. Your lordships have it, minutes. Yes. So this was withdrawn in the presence of the counsel for both the parties. Yes. Yes. On 8/7/2020. I'm grateful. So therefore, my lord, on that day also no objection was raised regarding that earlier petition filed. So 3 things I want to say. A, definitely it was a mistake. B, even though it was said so in the certificate, in paragraph 1 itself it was stated that he was an interim bail. Now that bail was never pursued. In fact, in 18th February, this memo was filed for withdrawal. Okay, leave it. Now you come to the on the bail application. Yes. Yes.
But I want to point out one thing, your lordships, if your lordship will permit me, or after the end of the submissions of Mr. Parija.
Carry on, no problem.
Yes. Your lordships, when this bail application was pending, the second bail application which was filed, your lordships, a modification application was filed. The date of the filing of the modification application, your lordship, is 9/12/2015 and 21. Lordship may note it down. An IA was filed. 9/12/2021. That IA number is 11025 of 2021, your lordships.
IA number
11025. The order in the IA was passed on 10/1/2022, your lordships.
In which BLAPL this IA was filed?
541, your lordships. The original, the first bail application which was filed.
541 of 2021.
Yes.
Yeah.
In that order, your lordships, modification of the first order was sought for.
What first order was passed? Let us see that.
First order of interim bail, your lordships.
Just a minute. When the interim bail was granted? 1611. 1611.
1611, your lordships.
1121.
Just a minute. 16, acha.
So this 16/11/2021 order, your lordships, a modification was filed.
16/11/2021. For what period he was granted interim?
6 months.
6 months. Okay.
If your lordship sees my list of dates, it is all there.
6 months bail granted. Yes. Then what happened? He
Then he
filed.
filed a modification application, your lordships. The date of filing of the modification application is 9/12/2021.
Right.
The person who argued, your lordships, the modification application, the same advocate, your lordships, had also filed this petition of the second bail, that is 23/12/2021.
Mm-hmm.
So when he has filed the modification application, your lordships, he had annexed that order, which is not available in the internet, your lordships. That order, your lordships, if your lordships has that order 16/11/2021, at the fag end of that order, your lordships, the date is given.
No, what happened to that IA?
Your lordships has that 16/11/2021 order?
No, about the modification application, you said it was filed on 9/12/2021.
Your lordships, if I remember, that IA was disposed of on 10/1/2022. I don't have that, but it was 100% dismissed on 10/1/2022.
122 order cover. Just a minute, let me see that. 10/1/22.
So in this,
I am not inclined to modify the order dated 16/11/2021. Therefore, the modification prayer then the IA stands dismissed. That is
yes.
the order.
Therefore, your lordship, the person who has filed the modification application, he has annexed that order. If your lordship will read that order, 16/11/2021, your lordship has that order?
Yes, sir.
Your lordship may come to the last part of the order where a date is given. If your lordships will remember,
to be listed on 20th June 2022.
So is this matter 1 week commencing from 20th June 2022?
Because 6 months granted.
Yes.
So that is why the date was fixed accordingly, and the petitioner's counsel was asked to file the surrender certificate.
Yes, and if both the counsels are same, your lordship, the person who has filed the second bail application and the person who has filed the modification application, the counsel, the first counsel and the second counsel, both are same.
Okay.
And when he has annexed this order, and in this order it is categorically written that the matter will be listed in June, therefore this is not a deliberate mistake, your lordships. This was a mistake to play fraud to the court and mislead the court, your lordships.
Okay. But
and secondly, your lordships, had it been once, your lordships, you would have presumed that it is accidental, or he made a mistake, or it is a bona fide mistake. Sir was not present on that day. Learned senior advocate Mr. Ashok Mahathi appeared initially. After that, your lordships, this modification application was filed by somebody else. I had pointed out, your lordships. When I pointed out, your lordships, he took time on that day. And your lordships, this compilation of this convenience note which sir has given, these has only the dates which is convenient to the accused, your lordships. Some of the dates are missing, your lordship: 36/2022, 8/7/2022, 13/4/2023, 2/5/2023, 7/8/2023. So this is a convenience note which is only convenient to the accused, your lordships.
Okay.
So now, your lordships, one crucial part, your lordships, he is enjoying the bail application, your lordship, since 1 year by again misrepresenting facts before the Honorable Supreme Court, your lordships. Lordship, this Supreme Court order.
Just a minute, Mr. Naik. He did not, you mean to say he did not surrender on 20th June 2022?
No, he surrendered, your lordships.
Okay, then?
He surrendered, your lordships, but he went to the Supreme Court. Supreme Court passed some order. He came before your lordships and lied that Supreme Court has passed certain orders. I'll demonstrate you, your lordship. Lordships, this convenience note doesn't contain order dated 13/4/2023. Your lordship may note it down.
A convenience note that one.
This is note रे note बनी चंदी तीनटा date छाड़ दी चंदी.
ये फाइल है नहीं ये फाइल है नहीं कन्वीनियंस नोट्स जो ଦେଇଥିଲେ କୋଉଠି ରଖିଲେ
It's a list of dates, the pages. 2 pages. You have extra copy.
Your Lordship will note the Supreme Court SLP. The Supreme Court SLP criminal number is 12474 of 2022.
Extra copy. Sign it, Chief. Nice.
1247 I got it, yes.
12474 of 2022, Your Lordships. This convenience note doesn't contain order dated 7/8/2023, 2/5/2023, and 13/4/2023.
Just so 12474 of 2022. That is against the order passed in IN number 1043 of 2022.
Yes.
It is 22/7/2022. 22/7/2022. So that is a subsequent order. By
Yes, Your Lordships. Coach, Your Lordships may kindly read the order dated 7/8/2000.
No, I want to see that against which order they have approached the Honorable Supreme Court. That
they had 22/7/2022 order, Your Lordships.
That is IN number 1. So what was done in that case? They considering the submission and so on, keeping in view an instruction obtained by the land order dated so on, so modify. And instead of filing an undertaking before the land and trial court to the effect that the deposit 5 installment each month. If Keshav Pradhan files security bond and produce the original document, a record of right and EC, every now next to so on, so the memo dated filed before this court and verified by the land special public, same shall be accepted and petitioner shall be released on interim bill for the remaining period as per order dated so on. So copies of the documents which are filed before this court along with so on so will be sent to the registry. Okay. So against this order, he approached the Honorable Supreme Court.
Yes.
And the Honorable Supreme Court so say order to the
Your Lordship may kindly come to the last order, which is not in the convenience note, 7/8/2023, Your Lordships.
The interim protection granted to the so and so shall continue to operate till the disposal of the bail application after restoration. Which restoration? What restoration?
Restoration, because Your Lordship, it did not appear on that day. It was dismissed by default for non-appearance.
BLAPL?
Present BLAPL. Present BLAPL.
541. Okay. So
and your
now by virtue of this order, he is now on interim bail, as you said.
Oh, Your Lordships, he is enjoying the interim bail by lying before the Honorable High Court and also the Supreme Court, Your Lordships. Therefore, Your Lordship, this order dated 7/8/2023 needs to be perused by Your Lordships, which is not in this convenience note. 7/8/2023.
Let us see that.
Yes.
7/8/23 is on two things. There is no order on 7/8/23 in that is
Supreme Court.
Oh, Honorable Supreme Court order.
Yes, Your Lordships.
That is, of course, that is 7/8/23. Yes.
I want to read it, Your Lordships. May I read, Your Lordships, with your permission?
Yes, of course.
Dr. Menaka Guruswamy, Learned Senior Counsel, appearing for the petitioner, submits that due to the incorrect instructions given by the Learned Counsel appearing for the petitioner before the High Court of Orissa, to the effect that an application shall be moved before this court for correction in the order passed on 6th January 2023, the petitioner has withdrawn the power of attorney in favor of the said counsel and has engaged a new counsel. So he's saying that the counsel who was appearing, Your Lordships, I don't want to name him, due to the incorrect instructions given by the Learned Counsel appearing for the petitioner before the High Court. and has engaged a new counsel. In the meantime, due to the absence of a no objection certificate from the previous counsel, none appeared on behalf of the petitioner before the High Court on 3rd July, resulting in such and such. Now, your lordship, what is that incorrect instruction which the Supreme Court advocate is talking about?
Yeah.
Lordship may kindly come to order dated. Your lordship may kindly come to order which starts from 13/4/2023.
Hmm. Yes.
It was argued, your lordships. It was argued before your lordships.
Hmm. Hmm. Okay. Yes, I gone
It
through
was
this.
argued before your lordship that the bail application which is pending before the Supreme Court, the Supreme Court will dispose of the application, not your lordships.
Hmm.
But the direction of the Supreme Court was that your lordships will dispose of the application.
Hmm.
So a wrong statement was made before your lordships that an application will be moved before the Supreme Court to correct that order that the Supreme Court is going to dispose it of. But the Supreme Court said that we have not passed any that order. This is in fact a wrong instructions given by the petitioner to the advocate.
Okay.
Until that point of time, till now, your lordships is enjoying the interim bail by playing fraud to the court, your lordships.
Hmm.
Lordship may read the submission of Mr.
Yes.
Lordship's order dated 2/5/2023. Order dated 2/5/2023.
Yeah.
Mr. Panda, learned counsel appearing for the petitioner, submitted that inadvertently in the order dated Honorable Supreme Court dated 6/1/2023, it has been mentioned that the stay order is extended till the bail application is considered and disposed of by the High Court. But in fact, it should be the SLP is considered and disposed of by the Honorable Supreme Court, and in that respect, learned counsel for the Supreme Court has been instructed to move necessary application for the correction of the order dated 6/1/2023. And he has not obtained any instruction as to whether the application has been moved or not. The counsel for the Supreme Court is saying that no such direction has been passed by the Honorable Supreme Court. Therefore, your lordships, he has given wrong instructions to Mr. Panda, as a result of which your lordship till now he is enjoying the interim bail application since 1 year. And in Supreme Court, he went and said that we have never said anything to Mr. Panda. He said it on his own.
Okay. Okay. Yes.
Therefore, the matter was remanded back.
All right. So now all those submissions I will take care of. Now let us hear the matter on merit. Yes, Mr. Pariga.
Yes, Miller. I'm ready. Where is my convenience note? I made a chart with submissions. So if your lordship sees my convenience note, Miller, I've given an extra copy. On the last date I had submitted to your lordships. Kindly see page 2, Miller. Let us start from page 1. Miller, there are 3 FIRs. And the total amount is 23 crores. Now, my lord, on 31st of December 2020, the charge sheet has been filed in all the 3 cases. If my lords kindly turns over the page, my lords. Total number of witnesses are 96 and number of documents are 457. Charge has not yet been framed. 1 year, 6 months have passed in the meanwhile. Now, your lordships directed, my lords, interim bail on 16/11. And your lordships had directed that you pay 2 crores bail bond of 2 lakhs each. And your lordships had said to deposit 3 crores, 50 lakhs every month. Now, my lord, then the matter was carried to the Supreme Court for modification. Your lordships will see it is 10th of January 2022.
And the Honorable Supreme Court gave us liberty to approach your lordships and file documents relating to immovable property offered in lieu of cash. And my lords, on 22/7/2022, were pleased to convert it to property security subject to verification. Now, my lord, on 29/7/2022, I was once again released on interim bail for 5 months and 11 days. And on 14/12, the Honorable Supreme Court stayed the direction of your lordship to surrender before the trial court until further orders. And then, my lord, the Supreme Court has disposed of the SLP in the meanwhile. I will show the orders also. So my submissions are the following. 23.07 crores was the outstanding, 24.40 crores by way of cash and property security secured. Your lordships had directed that I will appear before the trial court on each day. 68 hearings have happened and I have appeared on all the dates. And then have said that 96 witnesses, 457 documents, and trial has not begun. And I have not violated any of the bail conditions which my lords had imposed. Now, lordship may kindly see, let's take that volume of Supreme Court judgments. No. Yes. You mean to say that charge has not yet been framed?
No.
No. Why? What is the reason for?
No, I don't know.
Mr. Nayak. So, if
Your lordship, there are other accused also. Those who are these small borrowers, your lordships, in whose name he has done fraud and 468. There are other, your lordship, 20-30 accused. So it is for their presence, your lordships.
They are yet to be apprehended or what?
No, your lordship, it is for their appearance only.
Appearance. That means they have been released on bail and for
only
appearance.
These two were arrested, your lordship. Ashwini Patra and Uma Shankar Patra were arrested. The other people were never arrested, your lordships.
Oh, I see. So this is the state of affair. All right.
My lord. And if your lordship may kindly see page 23 of that compilation, those judgments.
So, by the way, when you were initially taken into custody, till you were granted interim bail. When?
Lord, 1.5 years he was inside.
Okay. That must have been stated in that order dated 16/11.
I'm grateful.
So, where is that order? Let me see that. 16/11. Have you given that order?
Yes, 16/11. Lordship may kindly turn to page 6 of that compilation.
16/11. Okay.
My lords have it, my lords. Order number 8. My lords have it.
Yes.
Heard Mr. So-and-so, my lords. This is an application for bail under section so-and-so in connection with TR case number so-and-so. Pending in the Court of Learned Additional Session Judge cum Special Judge CBI Bhubaneswar for alleged commission of offences under section so-and-so. Petitioners moved an application for bail before the Court of the Additional Session Judge cum Special Judge CBI on so-and-so. As per the order dated 9/11/21, this court observed as follows. To test the bona fides of the petitioner to clear up a part of the outstanding dues to the tune of rupees so-and-so, it was suggested to the learned counsel for the petitioner to obtain instructions if the petitioner is ready and willing to deposit 50 lakhs every month for a continuous period of 6 months, to which the learned counsel for the petitioner sought some time to file an affidavit to that effect, giving a copy thereof to Mr. Nayak, learned special public prosecutor for the CBI on so-and-so. Pursuant to the aforesaid order, an affidavit has been filed by so-and-so, in which in paragraph 4 it is mentioned as follows.
Yeah, I have gone through, Mr.
Yes, Lordship. My lord. And my lord, if your lordships now sees one more order, my lords, kindly turn to page 11. My lords have page 11, my lords.
Yes.
And the order begins at page 12. And this was passed in the presence of the learned Additional Solicitor General appearing for the CBI. And if your lordship straightaway comes to paragraph 6, my lords have para 6. In view of the above, the petitioner would be at liberty to submit the relevant documents relating to immovable property offered by him in lieu of cash security. If the High Court is satisfied with the same, it may consider accepting the immovable property as a security in lieu of cash security for releasing the petitioner on bail. Now kindly see page 13, my lord. Your lordship's order of 22/7/2022. Where, my lords? If your lordships come to page 15, considering the submissions, my lordships have it. Yes. Submissions by the learned counsel for the respective parties, keeping in view the aforesaid order passed by the Honorable Supreme Court and so, and the instructions obtained by the learned special public prosecutor dated so, the order dated so. Instructions obtained by a special prosecutor, the order dated so is modified to the extent that instead of filing an undertaking before the learned trial court to the effect that the petitioner shall deposit a sum of so in 5 equal installments every month, if Kesha Pradhan files security bond and produces the original document, that is record of rights and EC, which have been annexed as Annexure 1 series to the memo dated so filed before this court and verified by the learned special prosecutor, the same shall be accepted and the petitioner shall be released on interim bail for the remaining period as per the order dated so. Copies of the documents which are filed before this court along with memo dated so shall be sent to the registry. This is how your lordship modified that order. Now kindly turn to page 17. The next order at page 18 was the direction to surrender had remained stayed. Your lordships have it correct at page 18. Yes. Then at page 19, is that order that the interim order is to continue till disposal of this present application.
Correct. Submission made.
So this is pointed out by Mr. Naik.
Yes, sir.
That on 6/1/2023.
Yes.
Even though the order is very clear that the benefit shall NEO to the petitioner till the bail application is considered and disposed of by the High Court.
Correct.
But submission was made that perhaps it is wrongly mentioned or inadvertently it is mentioned. It should have been by the Honorable Supreme Court. That is why he took time.
Yes, sir.
And he enjoyed 1.5 years, your lordships, after that.
Right.
So kindly see page 23 minutes.
23.
Thereafter, my lords.
Order dated
7th of August 2023.
Yes.
7th of August. My lordships have it, page 23. Mr. Dr. So-and-so learned counsel for the petition, appearing for the petitioner, submits that due to incorrect instructions given by the learned counsel appearing for the petitioner before the High Court of Orissa, to the effect that an application shall be moved before this court for correction in the order passed on 6th July. 6th of January 2023, the petitioner has withdrawn the power of attorney, so-and-so, may leave that. In the meantime, lordship sees that minutes? In the meantime, so that part is not taken care. In the meantime, due to the absence of no objection certificate from the previous counsel, none appeared on behalf of the petitioner before the High Court and so, resulting in dismissal of his bail application for non-prosecution. It is submitted that steps have been taken to move an application for restoration of the bail application by the newly engaged counsel at the request list after 4 weeks in view of the statement made here and above, interim protection granted to the representation country. So there was no suppression. Kindly look at page 25 minutes. 25, your lordships, now restore the bail application. And page 28 is the last order. You know, this restoration, because there are 3 bail applications, your lordships have passed 3 orders. Now come to page 28, my lords. I'm sorry.
What Mr. Naik sees,
yes, madam,
that when the order dated 6/1/23 was passed,
6/1/2023,
that is at page 19.
Yes, madam.
That was passed.
Yes, madam.
If such a submission would not have been made, on 2/5/2023. Then
On
definitely
2/5, let me just see.
2/5/23, that is the next page.
2/5/2023.
So once I pay you this order, I would have definitely taken care to see that the matter is earlier disposed of.
Yes, my lord.
And because you made a submission,
Yes.
therefore I adjourn the matter,
Yes.
and then you approve the Supreme Court, and all these things happened.
But that
So
part
was
of
a clear
so that part, my lord,
thing which was to mislead this court. That
Yes,
is
yes.
that is what he's saying.
This time it was pending before.
No, that is a fact, Your Lordship. That is not what I'm saying. Mr. Panda, learned counsel appearing for the petitioner, submitted that inadvertently in the order dated such and such of the Honorable Supreme Court, it has been mentioned that the stay order is extended till the bail application is considered and disposed of by the High Court. But in fact, it should be the SLP is considered and disposed of by the Honorable Supreme Court. In that respect, learned counsel for the Supreme Court has been instructed. That means there is a communication, Your Lordships. A very responsible senior advocate is making a submission that he has communicated to the Supreme Court that you move a application. Therefore, Your Lordships, it must have been done with the instructions of the client.
It's taken care here, no?
It has to be, Your Lordships, with the instructions of the client to mislead the advocate to make a wrong submission. And the advocate is saying that I have communicated to the Supreme Court, Dr. Guru Swami or somebody, and she is going and making a statement that the advocate is making wrong submissions and nothing has been done and we have taken an NOC.
So
and
that
due
is
to that, Your Lordships, he enjoyed the interim bail application for 1 more year and never perused the matter, Your Lordships. Because I remember, Your Lordships, Mr. Learned Senior Counsel was not there on that day. Your Lordships wanted to dispose of. After hearing the submissions of Mr. Panda, Your Lordships adjourned the matter. Then, Your Lordships, in the interagnum period, 1 year passed away. In fact, Your Lordships,
Usually, once such type of order comes to my notice, I used to take it off an early because he is enjoying the interim bail order, which is extended, and there was a direction that benefits should endure till the disposal of the bail application. So that was the usual thing which is done. But since such a submission was made, it was obviously urgent. All right. So
therefore, my lords, after 2nd of May, if your lordship now sees this order of the Supreme Court at page 23, at page 24, that has already been addressed.
So now your submission is mainly basing on that period of detention to some extent and about the delay in commencement of the trial.
I'm grateful. Article 21, that's all.
I would like to
citation, if you want to give, you can give it.
I will give us a list of citations.
Right.
Citation, I would like to read, Your Lordship, only 2 lines.
Yes.
A person who makes a false statement before the court and makes an attempt to deceive the court interferes with the administration of justice and is guilty of contempt of court. The court not only has the inherent power, but it would be failing in its duty if the alleged contemptor is not dealt with in contempt jurisdiction for abusing the process of the court. Lordship, take this judgment into record. And recently, Your Lordships, one NDPS case which has gone to the Supreme Court, Your Lordships. Lordships must be aware of that judgment, recent judgment, Your Lordships. Krusa Daruka versus State of Orissa. I'll file both the judgments, Your Lordships.
Please file it. During course of the day, give it to, I ask your associate to give the just reference of those 2 cases, if not the Xerox copies, so that to my court master, so that it will be placed on record. And Mr. Parija,
yes, I will also give minute. Therefore, I was only saying minutes. That the certificate read with paragraph 1, read with the enclosure, wherein interim order has been passed, read with the memo, and the order of withdrawal, which was passed in the presence of counsels for both the sides. Definitely, my lords, indicates it was a mistake, and there is one judgment of the Supreme Court Justice Desai, paragraph 3 and 4. I leave it for your lordship to read. It says that if there is some act of mistake or negligence by the counsel for having filed an affidavit, then it should not inure to the disadvantage of the client. So I will give all those judgments, Your Lordship.
With due respect, Your Lordship, only one last line. Your Lordship, this is not a negligence. This is a deliberate mistake because of the fact that the modification application was filed by him. He argued it, and in the modification application, the last order was annexed to your Lordships, which shows that the matter will be listed on June 2.
Faria, just
Yes.
ask your associate to highlight those paragraphs
Yes. Yes.
which you are relying.
Correct.
Mr. Nayak,
Yes.
if you are filing any citation today, just give those relevant paragraph numbers.
Yes.
Okay, on this particular issue, you are placing reliance on this particular paragraph. That
Yes,
should
Your
be during course of it. All right. Hard Mr. Farijal and senior advocate appearing for the petitioner, and Mr. Sarthak Naik, Learning Special Public Prosecutor for CBI. Hearing is closed. Order is there.
Grateful gods.
Yeah. This should be the order in all the three. There are three GA, right? So it should be mentioned. Okay.
Open close.
May it please your lords. The lordship had called for a custody.
Ninth, okay. So the order was you are to obtain custody certificate
and see.
Okay. Heard Mr. Basudev Pujari and Mr. Tripathi, the Learning Council for the state submitted that custody certificate and instruction regarding criminal antecedent has already been sought for, but it is yet to be received, and the matter may be taken up next week as paid for this matter on 9th August 2024.
Item number 5.
Item 5, my lord. Custody since 7/9/2017, my lord. 6 years, 10 months, 27 days, my lord. Appellant is an old man, aged about
Just a minute. Mr. Tripathi,
Yes, my lord.
in this case also, you are asked to produce the custody certificate and that is it there?
Yes, here is not. Instruction not from.
no, see.
No, he has produced it from the
Yes.
senior superintendent. So the period, it is indicated that 6 years, 10 months, 23
Yes.
days.
Yes, my
And
lord.
it is a report custody certificate is dated 29/7/24. So what is the sentence imposed?
10 years, my lord.
And conviction is under section?
3762I and 3762N of IPC.
Okay. What about the criminal antecedent, Mr.
No antecedent, my lord.
That is not.
72 years old, no antecedent.
Are the Learning Council for the Petitioner and Council for the State. This is IN number 91 of 2024, right? The Learning Council for the Petitioner has produced the custody certificate issued by custody certificate of the petitioner issued by Senior Superintendent Circle Jail Baripada dated 29/7/2024, which indicates that the period of detention is 6 years, 10 months, and 23 days. The custody certificate is taken on record. Though time was granted to the Learning Council for the state to obtain instruction regarding criminal antecedent, if any, against the petitioner, Learning Council for the state has not obtained the same. The Learning Council for the petitioner submitted that the petitioner is aged more than 70 years and the paperwork has not been prepared and therefore there is no chance of early hearing and the of any chance of early hearing of the appeal in near future. I am inclined to release the petitioner on bail subject to condition that he shall not try to come in contact with the victim or any of our family members and shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail. Bail allowed.
Item number 6.
My lord, in this matter, I am through VC Lordship. Lordship, in this matter, I am humbly praying for last opportunity to furnish the fresh security document, Lordship. And today itself, I will submit it, my lords. Since the last document was not genuine as per the ordership. My lordship, actually, I am also not there in that place. And the person is in jail. So it has been got from some third person. So I tender my apology for that, my lords. But just praying for last opportunity to furnish the fresh document.
Mr. Sam Manohar, Learned Counsel for the petitioner appearing through virtual mode submits that he may be given some further time to produce the names, documents, and names, address, and documents of phrase local surety. Put up this matter on 16th of August 2024. If in the meantime the same is supplied to the Learned Council for the state, instructions shall be obtained. Yes, it will come on 16th August 2024. Yes.
Lordship, obliged, Lordship.
Item 7.
May plus. This is the second.
On the last occasion, your lordship directed me to file a comprehensive affidavit, my lord, regarding the criminal antecedents of the present petitioner. But your lordship, can you take up this matter on 16th, my lord? I am yet to receive the certified copy of the...
Mr. Biswajit Nayak, Land Counsel, appearing for the petitioner, submitted that you are supposed to file a comprehensive affidavit relating to the status of the 5 criminal antecedent against the petitioner, and the matter may be taken off a week after. Stop. List this matter on 16th of August 2024. In the meantime, the comprehensive affidavit be filed, serving a copy on the Land and Council for the state.
Item 11.
11 madam, permitted to withdraw with liberty to move later stage, madam.
Letter state. Are you filing any memo? Have you got any power in this case?
On behalf of Mr. Suryakant Dwivedi.
What is your good name?
Satya Shiva Das.
Huh?
Satya Shiva Das.
Mr. Satya Shiva Das, Land and Council, appearing for Mr. Suryakant Dwivedi, submitted that he has been instructed by his senior to make a mention for withdrawal of the bail application. In view of such submission, BLAPL is disposed of as withdrawn. Yes.
Item number 12.
May please lordship, my lord. On last occasion, order dated 22/7/2024, your lordship directed to furnish the local security name and address. We will also furnish.
So instruction has been received.
Yes.
I have verified the criminal antecedent of Bail or Panchu Nayak and found a case has been registered against so and in which he has been charge sheeted. Nothing adverse against the other bailer, Gopinath Nayak. During address verification, Panchu Nayak and so, they stated that they do not know so and not interested to stand. आपण जो बेलर को ना देइथिले सेमाने इंटरेस्टेड नहुंती आपनकु सिक्यूरिटी हिसाब रे नबा पई तेणु आपनकु फ्रेश बेलर दबाकु पड़ियो हला period the written instruction received from IIC Mohana Police Station dated 29/7/2024, which is produced by the Land and Council for the state in pursuance of the order dated 22/7/2024, in which it is mentioned that the 2 bailers whose names, address, and documents have been furnished by the Land and Council for the petitioner are not interested to stand as sureties for the petitioner. The written instruction is taken on record. The Land and Council for the petitioner submits that he may be given some further time to produce the names, address, and documents of 2 fresh local sureties. This matter on such and such date. If in the meantime the same is produced, same is furnished to the State Council, he will obtain necessary instruction in that respect. Okay.
Oh, bless you.
Yes.
Item 13.
Mr. Pradhan.
Custody since 9/8/2020.
Mr. Tripathi.
Yes, sir.
You took time last time on for this case diary and also criminal antecedent, if any.
That has not come.
What has not come? Case diary has seen in a criminal antecedent has seen. instruction short for କରିଛନ୍ତି
Yes, yes.
26/7
4/4/24 and on 30/7 last minute.
ଆପଣଙ୍କର ପୋଲିସ ଅଫିସର ଆପଣଙ୍କ କଥା ଶୁଣୁନାହାନ୍ତି ଯଦି ଅନ୍ୟ
GRP ଥାନା
ସେ ଯୋଉ ଥାନା ହଉ ବାଟ ଅଛି କେମିତି ଆଣି ପହଞ୍ଚେଇବେ ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ଆପଣ ନିଜେ ପ୍ରଡ୍ୟୁସ କରନ୍ତୁ ନହେଲେ the court will see that it is produced on the next date. What do you want? You produce?
next week I will try.
All right. The Learned Council for the state submits that the matter may be taken up next week to produce the case diary. So also the instruction relating to criminal antecedent, if any, against the petitioner. Put up this matter on 9th August 2024.
Item 15.
Malad, on behalf of Amlinathna Panda, I may be permitted, Malad.
Yeah.
Malad, on the last occasion, Lordship has called for the status report.
Status report, it has been received and it indicates out of 38 charge sheet witnesses, 2 witnesses have been examined.
Malad.
Then that was earlier. Then some further development has been made. Okay. No, that is the stage. That is the stage. What is the offense here? Huh?
Malad.
What is the offense?
Offense, Malad, 20B, 2C by 29 of NDPS Act. And Malad, 109, 147, 148.
Including 395 is also
Malad,
there.
Malad. And some of the co-accused persons were also already released on bail by the Honorable Court, Malad.
You are granted interim bail.
Yes, Malad. And surrender, Malad.
So, Mr. Tripathi,
Yes.
so have you obtained instruction whether he has flouted the terms and conditions?
Your Lordship has granted interim bail on dated 14/12/2023, and the surrender date was fixed to 3/4/23, but he surrendered on 5/4/2023.
No, we are on the misutilization of liberty. That lucky don't. Period the status report furnished by the London Trial Court, which indicates that out of 38 charge sheet witnesses, 2 witnesses have been examined. The London Council for the petitioner submitted that the petitioner is in judicial custody since
9/1/2020.
was taken into judicial custody on
Custody 9/1/2021.
9/1/2021, and he was directed to be released on bail for a period, interim bail, for a period of 3 months in BLAPL number 5243 of 2022 as per order dated 14/12/2022.
23.
14/12/2022 पर
Malad, I'm checking. I'm checking, Malad.
Order लिखा है 14/12/2022. The learned counsel for the state obtain instruction as to whether there is any allegation of misutilization of liberty by the petitioner while on interim bail. Put up this matter on 16th of August 2024. Yes, madam.
Item 15.
My pleasure. Pursuant to Lordship direction, my lord, I have supplied all the copies to my learned friend, my lord. The judgment of the trial courts, my lord, in passed in two cases, my lord. Case of 2012, my lord. Earlier, my lord, 18 persons faced trial in the 2012. Out of 18 persons, my lord,
What is the offense here?
Offense, my lord, 302. My lord, 147, 140, 395, 302, 307, 294.
Just a minute.
My lord. The FIR, my lord.
Wait.
My lord.
Yes, what is the custody date?
My lord.
Since when you are in custody?
My lord, 15/9/2023, my lord.
15/9/2023.
My
Charge sheet under section?
Charge sheet, my lord, under section 147, 148, 395, 302, 307, 294.
So, who is the deceased?
Deceased, my lord, one Narendra Patel.
Narendra?
Patel, my lord.
Date of occurrence?
Date of occurrence, my lord, on 11/8/2012.
Now, what order was passed in your earlier bail application?
Earlier bail application, my lord, he moved an application under section 438, my lord.
No, 439?
439, this is a
You have
first.
never. So, what you said that earlier a set of accused persons faced trial.
Faced trial.
What is the total number?
18, my lord.
18. So, what happened in that case?
17 persons were convicted.
17 convicted.
1 acquitted, my
lord. 1 acquitted.
And the 17 persons, my lord, filed a criminal appeal here, my lord. And this honorable court, after my lord, was pleased to, my lord, grant all of them on bail. All of them were on bail now.
And
then, my lord, 2 persons faced trial. Out of 2, my lord, 1 person was convicted and another was acquitted. And who was convicted, my lord, he approved this honorable court, again filed a CRLA, wherein he is in bail. And pursuant to Lordship's direction, my lord, I have given the deposition copies of the 2 criminal trial, my lord, to my lord and friend.
What evidence has come against you in those trials?
Nothing.
Mr.
Eyewitness who
Eyewitness.
161 statement I have.
No. In the trial.
The other cases.
No.
He was the absconder.
Absconder je ta na କହିଥିବ ଅନ୍ୟ ମାନଙ୍କର ଇଏ
He was not present at the dock.
ଡକ୍ ରେ ନାହିଁ କିନ୍ତୁ ସପୋର୍ଟ କଲେ prosecution case କୁ support କରିଥିଲେ. So eyewitnesses have supported the prosecution case. Not specifically named this man.
Because he was not present at
Right.
the dock.
Only one witness, my lord, has whispered the name of the present petitioner who was there in the congregation. And very specific allegations in all the 2 cases, my lord, who was assaulted, my lord, and how the assault was made, my lord, that was very specifically stated by the.
So now what is the stage of trial? Whether trial has commenced?
Trial has commenced, my lord, and major witnesses have been examined, my lord.
So Now, in the present trial,
In the present.
what evidence has come against you? That is, you mean to say 200 by 5 of 2023.
That is copy has not served up.
That depositions copies
You obtain those deposition copies, and let us see that what witnesses have stated against you. Lekhon.
Let's say, can you put it on 16th, my lord? In the meantime, I will serve.
Okay. The learned counsel for the petitioner submitted that the occurrence in question took place on 11/8/2012, and initially 18 accused persons faced trial. Out of them, 17 have been convicted under various offences. 302 members of conviction, including under section 302 IPC, and one was acquitted. And the persons convicted preferred criminal appeal before this court, and they have been granted bail. Subsequently, 2 more accused faced trial, out of which one was convicted and the other was acquitted, and the accused was convicted, preferred criminal appeal before this court, and he has also been granted bail. He further submits that the petitioner is in judicial custody since 15/9/2023, and trial has commenced, and the matter may be taken off on 16th August 2024, so that he will produce the deposition copies of all the witnesses examined so far in the trial court, serving copy thereof on the learned counsel for the state. Put up this matter on 16th August 2024.
Published.
Item 16.
Lordship, please.
Yeah.
Here the petitioners have been arraigned for offence under section 302.
Have you received the case diary?
The deposition copy, case diary or
Lordship. So, Mr. Das, you come earlier also, or this is the first application?
Earlier I was there before. Yes, in BLFP.
That, yes, one BLFP is there mentioned as
9853.
9853 of 2021. Okay, let us see what order has been passed. So that was rejected. BLFL 9853
and 9858.
2021. No, your bill application number is 9853 of 21. The 9858 is by one Vishwambar Singh.
Vishwambar Singh, my lord. Both the petitioners are before your lordship.
Yeah, in this BLFL, both are there.
Lordships.
Okay.
They were taken up together.
Okay, it's all right. So BLFL 9858 of 2021. So rejected on
22/11.
22/11/2022. What is the period of your detention?
Lordships. Since 14/9/2020, the petitioners are suffering incarceration.
And what are the offences under which charge sheet submitted?
Lordships, 302,
yes,
201, 120B, read with 34 of IPC rules.
What is the name of the deceased?
Deceased is Mongoli. Deceased happens to be the stepmother of these petitioners. The deceased was third wife of the petitioner's father. Petitioner's father, Millets, PW2 has been examined. As per the FIR version also, is stated to be the only eyewitness.
And turned hostile.
PW2 is the eyewitness.
Is said to be the eyewitness, yes.
And turned hostile.
He has turned hostile.
PW2 is your father.
Father of the petitioners.
Both the petitioners.
Both the petitioners, Millets. Both the petitioners are brothers. PW2 happens to be the husband of the deceased, Millets.
Right. So, any other important witnesses left out to be examined, Mr. Tripathi?
Yes.
Yes. The complainant, Millets.
Now, what is the total number of witnesses as per charge sheet?
14.
How many of them have been examined?
8 have been examined, Your Lordships.
And till date, what evidence has come on record against you?
Turned hostile.
Nothing, Millets.
All hostile.
6 of them have turned hostile, except for the medical evidence.
Informant is to be examined.
Yes. Informant is to be examined.
What he has stated? What is his statement? Any thing there?
If Your Lordship takes that FIR narration for a moment at page 9, the informant says that he was not present at the time of occurrence at the spot, but he was informed by the husband of the deceased.
No, from this FIR, nothing reveals. What is the 161? Whether he was there at the spot or subsequently he came to know about the occurrence. 161 of Damu Singh. Have you got a copy of that 161? No, you place that. Please place. Damu Singh. ସେ ଯୋଉ କହୁନାହାନ୍ତି ପରେ ଜାଣିବାକୁ ପାଇଲା
ଆଜ୍ଞା
ସେଇ ପୋର୍ସନ ଟା ପଢନ୍ତୁ ତାକୁ କିଏ ଖବର ଦେଲା ଗତକାଲି ରାତି ପ୍ରାୟ 3ଟା ସମୟରେ ମଣ୍ଟୁ ସିଂ ମୋ ଘରକୁ ଯାଇ ଶୋଇବା ଅବସ୍ଥାରେ ଉଠାଇ କହିଲେ ଯେ ତୋର ଭଉଣୀ ଜୀବନ ନାହିଁ ତାକୁ ଶୁଆଣ ଶୋ so obviously from the FIR it revealed that he is a post occurrence witness. Heard the learned counsel for the petitioners, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioners earlier approached this court in BLAPL number 9853 of 2021 and 9858 of 2021, and both the matters were heard analogously and disposed of by order dated 22/11/2022, and the bail applications were rejected. He submitted that the petitioners were taken into judicial custody on 14/9/2020 and they have been charge sheeted under section 302, 201, 120B by 34 of the Indian Penal Code. The deceased Monguli happened to be the stepmother of both the petitioners, and she was the third wife of the father of the petitioners. And in the case in hand, PW2, who is the father of the petitioners and husband of the deceased Mongoli, was the only eyewitness to the occurrence, and he has been examined in the trial court as PW2, but has not supported the prosecution case for which he has been declared hostile. And in the trial court, out of 14 charge sheet witnesses, 8 witnesses have been examined, out of which 6 have turned hostile. Though informant is yet to be examined in the case, but he is a post-occurrence witness, and therefore, in view of the period of detention of the petitioner in judicial custody and change in the circumstances after rejection of the earlier bail application, the bail application of the petitioners may be favorably considered. Learned counsel for the state has produced the case diary, and after going through the deposition copies of the witnesses, fairly submits that till now nothing has come on record against the petitioners during the trial. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced so far in the trial court, and taking into account the period of detention in judicial custody, I am inclined to reconsider the prayer for bail and direct the petitioners to be released on bail subject to condition that they shall appear before the learned trial court on each date, and the case should be posted for trial, and shall not try to tamper with the evidence, and shall not indulge in any criminal activities, violation of any terms and condition, shall entail cancellation of bail allowed.
Grateful minutes.
Item 17.
May please last. Last occasion order dated 22/7/2024. So directed to the instruction regarding the bail details.
Yes, Mr. Tripathi or Mrs. Sahoo.
IIC prays for 1 week time for verification. Also, SP also prays for 1 week time.
So whether it would be proper to keep it on 9th or 16th? That is the calendar.
9th of next week.
16 May.
16th.
SP already sent.
All right. The learned counsel for the state submitted that after receiving the documents from the learned counsel for the petitioners relating to two local sureties, instruction has already been sought for, and the matter may be taken up a week after. Put up this matter on 16th of August 2024.
Obligation.
Item 18.
I am pleased, Your Lordship. Last occasion, Your Lordship has directed to take instruction whether the petitioner has misutilized his liberty after getting 4 times interim bail.
When you were granted interim bail last time?
1101 of 23, order dated 19/5/23.
Now, what is the trial position?
Only 7 witnesses have been examined out of 20, my lord.
No, that was earlier there. There is no progress in the meantime.
No, my lord.
That order dated 19/5. So
My
have
lord.
you obtained any document, because status report was not called for? Have you got any order sheet of the learned trial court
No,
to
ma'am.
show that? Okay, the learned counsel for the state has produced written instruction received from IIC Tarasinghi Police Station, Ganjam, that the petitioner has not misutilized the liberty while on interim bail. The instruction is taken on record. The learned counsel for the petitioner submitted that when the petitioner was granted interim bail last time in BLAPL number 1101 of 2023, as per order dated 19/5/2023, by that time, out of 20 charge sheet witnesses, 7 witnesses had been examined, and thereafter there is no progress in the trial. Let a status report be called for from so and so. Matter to be listed on 9th of August 2024.
Obliged.
Item 19.
Pardon me, Lord, I am on VC.
Yes.
The present petitioner is in jail custody since 5/11/2020, my Lord. And he was released on interim bail by your Lordship on 14/7/23 for a period of 3 months. And after completion of the 3 months, he has surrendered in due time. And the total quantity of ganja that is seized, alleged to have been recovered, is about 219.400 grams, my Lord.
Order that was passed on the last date.
Yes, my Lord.
You are to obtain instruction from the IIC regarding whether he has misutilized his liberty during the period of interim bail. That is from Padua Police Station. So, what is the instruction you have received?
Yet to be received, my lord. I have already sent the letter and already talked with the IIC, my lord, on the
So,
yesterday.
I am taking up this matter on 9th. Get it?
My lord.
The in pursuance of the order dated 22/7/2024, though status report has been received from the London Trial Court, but the London Council for the State is yet to receive the instruction from the concerned IIC as to whether there is any allegation of misutilization of liberty by the petitioner while on interim bail. And she prays for time till next week. Mr. Murthy, Land Council, T.N. Murthy Land Council is present through virtual High Court Koraput at Jaipur. Stop. Put up this matter on 9th August 2024. Instruction be obtained in the meantime. Yes.
Obliged, my Lord.
Item 20.
May I please, my lord? My lord, I pray for the last occasion your lordship has directed that to the petitioner to file an affidavit, my lord. The file has been transferred to me on 26, my lord.
A submission was made.
Yes, yes.
That the petitioner is ready and willing to deposit a sum of rupees 65 lakhs, right? So, because the charge sheet, as per the charge sheet, the cheating amount is 70 lakhs.
Yes,
and cash security has been furnished to the tune of rupees 5 lakhs when your wife was released on bail.
Yes, in same case number,
right,
my lord.
Obviously.
And she has deposited.
You are to file and you are to obtain instruction that how and by what installments you will deposit that amount, and to that effect you are to file an affidavit.
Yet to get any instruction, my lord.
So you want time?
I want time.
Next week or a week after?
A week after, my lord.
All right. London Council for the petitioner seeks for an adjournment for set for a 15 days to file an affidavit as per the order dated 21/3/2024. Put up this matter on 16th August. 16th August 2020.
Item 21.
Yes, Mr. Chan.
Item number 22.
Mr. Suchit Kumar Naik. Okay, no one is there. Pass over.
23.
Mrs. Sahoo.
Last occasion, petitioner counsel submitted to file fresh local security document, but one local security document filed, but another local.
No, there was a direction to give the two local sureties.
मतलब two local surety has been filed on 8/4/24 तापरे आउ गोटे
That was
देइछु
mentioned before your honor on the last occasion that fresh two local security document be filed before you.
No, what he says that earlier he filed two, and maybe that he found that one of them is not ready or something like that. That is why he give you another one.
No, previously, Betru Digal and Ajit Kumar Pradhan was filed by the petitioner counsel.
So, what instruction you have received about those two?
So,
See,
on the last occasion, he has mentioned before your honor that he was not placed on the earlier security document and fresh security document be filed. And also, he has filed another security document regarding Jogi Malik, only one minor.
so learn and counsel you give another.
मतलब से दीटा तो ऑलरेडी फाइल्ड अछि ता
ଆପଣ
ऊपर
କହିଛନ୍ତି ଆପଣ ଷ୍ଟେଟମେଣ୍ଟ ଦେଇଛନ୍ତି ଯେ ରିଲାଏ କରିବେନି ସେ ଉପରେ ନିଜେ କହିଛନ୍ତି ସେଥିପାଇଁ ସିଏ ଆଉ ତା ଉପରେ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିନାହାନ୍ତି ବର୍ତ୍ତମାନ ଆପଣ ଦିଟା ଲୋକାଲ ସିକ୍ୟୁରିଟି ଡକୁମେଣ୍ଟ ଦବାକୁ ପଡିବ ଏଇ କଥା ମଧ୍ୟ ଲାଷ୍ଟ ଅର୍ଡରରେ ଲେଖା ହେଇଛି ଆପଣ କହିଲେ ଦିଟା ଦବାକୁ ଗୋଟିଏ ଦେଇଛନ୍ତି ସେଇଥିପାଇଁ ସେ କହୁଛନ୍ତି ଆଉ ଗୋଟେ ଦିଅନ୍ତୁ ଏକାଥରେ ମଗେଇବେ
today I will file.
All right. So the Learned and Counsel for the state submitted that even though there was a direction as per order dated so and so to furnish the names, address, and documents of two local sureties, but the Learned and Counsel for the petitioner only supplied the documents relating to one local surety. Stop. Learned Counsel for the petitioner submit that during course of the day, Aji Devedo, you will furnish the name, address, and document of the another surety to the Learned Counsel for the state for verification. Put up this matter on 16th of August 2024. The verification report be produced by the Learned Counsel for the state on the next date. Yes.
Item 24.
24, Mr. Yes.
Map.
Ansari?
May I please, my lords?
Yes.
My lords, on last occasion, that is on 26th of July 2024, on the submission of the learned standing council, your lordship directed the notice to be issued on the mother of the deceased, my lord.
Okay. Yes, you have entered appearance for
My lord, I have put the co-accused bail application is 121 and 125, my lord.
this item is connected to those two items.
Co-accused.
What is the number?
My lord, 121 and
It is in the list today.
My lord,
What is your number?
121, 125.
All right. So, Mrs. Sahoo,
Regarding notice, no instruction has been issued, my lord. So kindly next week, ma'am.
the notice has to be as per the last order on 26/7.
I have sent.
Okay, you have sent to which police station? Town police station?
Town.
Sambalpur Town Police Station. And it is to be served on the, I have stated that the mother of the deceased, who is obviously a victim. Okay. There was a direction that mother of the deceased is at liberty to engage any counsel to oppose the prayer for bail. Acha, in your case, notice has not been issued. Okay, then what is the item? Let me see. Item number 121. And
Thank you.
121 টা বার করো 121 টা that is CRLA 379 of 24.
Right.
এটা জমা আসেনি এতে ফার্স্ট টাইম বোধ আসছি
Thank you.
আচ্ছা ଲେଖି ଦିଅନ୍ତୁ item number 121 and ଆଉ ଗୋଟେ କହିଲେ
125.
125
Thank you.
ତା ଦେହରେ ଏଇ ଯୋଉ ୟୁଜୁଆଲ ଅର୍ଡର ହୁଏନି SC/ST ର ତାକୁ ଇଏ କରିଦିଅନ୍ତୁ and land council for the state shall send intimation 25 ଟା ବର୍ତ୍ତମାନ ପଡିବ ଯୋଉଟା ଚାଲିଥିଲା sent intimation to the inspector in charge of Sambalpur Town Police Station that there are connected that this is the connected matters to CRLA number 326 of 2024 filed by Suffolk appellant Suffolk and she is at liberty to appear in this case also to oppose the prayer for bail. And this matter is to be listed along with CRLA number 326 of 2024 on 9th of August 2024. So you just give them additional information. Notice has to be, obviously, you have to serve as per the order passed in 326 on the mother of the deceased. But that is only passed in respect of 326. Okay. Now, in respect of all the bail applications, that is in item number 121, there are 3 bail applications. And in item number 125, there is 1 bail application. So this will also be heard along with that. Okay. With on 9/8/20 24. Yes, next.
Oh,
Supplies forward.
Item number 26.
6 last time notice are issued to informant.
Yes.
Notice ଅଛି
CRLA number 633 of 2024. Item number 26. Notice has been issued on the informant to be served on the informant. What is your instruction?
Extra copy not for now.
No, that is noting your notice. Short man, same day. Same day, short man. That is also.
Just give another copy. What is
Yes. For our office.
verify?
Yeah, another copy short man.
Okay, I'm bringing it to the next week. If you maybe that so learn counsel for the state seeks for an adjournment till next week to obtain instruction regarding service of notice on the informant. So also to produce the case diary and criminal instruction about the criminal antecedent. List this matter on 9th of August 2024.
Another copy is solved today.
Yes.
Item number 27.
May I please say? Your Lordship, by order dated 19/7/2024, Your Lordship has got for the report from the trial court regarding delay in examination third victim, Your Lordship. And what happened in in this case, the 3 victims are there. Were there? 2 victims already been examined last 1.5.
The report has been received.
Yes, Your Lord.
And in the report, it is stated that delay in examination of the third victim with the informant in this case is due non-availability of the victim at her furnished address. The IIC intimated this court that though he has deputed the staff to village so and so, which is the permanent address of the victim, and to so and so the address where the victim was residing at the time of incident, but the family members and the relatives of the victim expressed their ignorance about the present whereabouts of the victim, and the prosecution was directed to produce the victim for her examination, but the victim could not be produced. So and so endeavor has been made by directing the person to produce the victim. Simultaneously, letter was issued to SP for examination positively on the next day's posting is 382. Acha, asanda kali ki achi date ku SP ku intimation jaichi. So please wait till we get the. You also take instruction from the local council whether that witness is coming to give evidence that third victim tomorrow or not. Okay, and if he sees examined, then produce the certified copy. We'll take up this matter on 9th. Right?
That's it.
Period the status report submitted by the learned trial court, which reveals that the examination date of the third victim is posted to 3/8/2024. Learned counsel for the petitioner submits that the matter may be taken up next week to obtain instruction regarding such examination. Place this matter on 9th August 2024.
Number 28.
May I please, Your Lordship?
Yes.
Lordship, on the last occasion on 26/7/2024, Honorable Court directed me to file a comprehensive affidavit and status of these cases, which is pending against the present petitioner, my lord. And I have filed it before the Honorable Court and sent a mail to the Advocate General Office as well.
Okay, please see that whether it's available or not. There are as many as 14 criminal antecedents against you. So, Mrs. Sahoo, that comprehensive affidavit is available. He has sent it to the AG office. So,
I will verify.
And whether it is available in the court record?
On our record, it was not available, so I'll verify.
When you file Learning Council?
On 8 August.
8 କେବେ 1 ଗତକାଲି ଫାଇଲ କରିଛନ୍ତି?
ଆଜ୍ଞା।
All right. So the Mr. Your good name is Learning Council Divya Prakash Mishra. All right, Mr. Divya Prakash Mishra, Learning Council submits that as per order dated 26/7/2024 on 1/8/2024, he has filed the comprehensive affidavit relating to the criminal antecedents against the petitioner in court, so also send the same to the Advocate General Office. एटा कौन एथरे पठेइछंती तो आपनकर जो ईमेल ले
हम मेल करछ
email. Since the comprehensive affidavit is not on record, put up this matter on 9th August 2024, registry shall place the comprehensive affidavit on record and the Learning Council for the state shall also verify. Yes.
Number 29.
I may be email.
I may be pardon to mention my item 74, my lord.
Huh?
Item 74.
ଆପଣ ଦେଇନଥିଲେ କି ସେ
ନାଇଁ
କାଗଜ?
ମୁଁ ଭାବିଛି 100 ପରେ ନିଆଯାଉଛି ବୋଲି ମୁଁ ଟିକେ
ସେ ଗୋଟେ କଣ ଅଛି ଶୋଇଲା ପୁଅର ଭାଗ ନାହିଁ ନା କଣ? କଣ କରିବା?
after the mention matter my lord time permit my lord
ଆଚ୍ଛା,
taken
ହଉ।
at 74.
Lordship, item number 30, Lordship.
ହଁ ସରିଯାଉ। Yes. Mention.
Item number 50.
May I please? My lord, alleged offence is under section 30234 of IPC, my lord. Custody since 26/9/2020.
26?
9/2020. 2020.
When your last bail application was rejected?
Last bail application is rejected 5/5/2023, my lord.
In BLAPL number?
13100 of 2022.
Okay. There was a direction to the trial court to conclude the trial by end of December 2023.
My lord.
And by that time, when you moved the application, out of 32, 7 witnesses had already been examined. So now what is the position?
My lord, 12 number of
So out of 32, 12 have been examined.
my lord, I have already annexed
You have
all
annexed,
the deposition copy of
and the witnesses have supported the prosecution case. So
yes, my lord. PW5 is the
PW5.
that your lordship will consider last occasion.
Last occasion. So Ajit Singh alias Mania dealt blow on the neck and back by means of a knife to Birbal. So, what about your criminal antecedent?
Four criminal
antecedent.
Huh?
For criminal
For
antecedent,
criminal
my lord, I have already filed the comprehensive affidavit.
What sort of criminal antecedent you are having? What are the offenses?
Offenses, one is PS case number 50 of 2017, offense order section 341, 294, 323, 324, 506, 34 of IPC.
Yes,
Second,
Mr. Tripathi.
All are 323, 506.
Since the earlier order has not been complied with, so let him go on interim bail for some time. Let us see his conduct. Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioner was taken into judicial custody on 26/9/2020. Last time when the petitioner approached this court for bail in BLAPL number 13100 of 2022, as per order dated 5/5/2023, while rejecting the application for bail, liberty was granted to the London trial court was directed to expedite the trial and conclude the same by end of December 2023, and the petitioner was granted liberty to renew the prayer for bail if the trial is not concluded within the aforesaid period. It is submitted by that time out of 32 charge sheet witnesses, 7 witnesses had been examined, but now only 12 witnesses have been examined out of 32, and therefore the order passed by this court in the last bail application has not been complied with. Learning counsel for the state, on the other hand, opposed the prayer for bail and placed the evidence of PW5, an eyewitness to the occurrence. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced so far in the trial court, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody, And since the order passed by this court in the last bail application has not been complied with, in view of the delay in disposal of the trial, I am inclined to release the petitioner on interim bail for a period of 3 months. While on interim bail, he shall not try to keep any contact with the prosecution witnesses, shall not indulge in any criminal activities, appear before the trial court on each date when the case be posted for trial, violation of any terms and condition shall entail cancellation of bail. Land counsel for the issue state out submits that the petitioner has got some criminal antecedent. Land counsel for the petitioner has filed a comprehensive affidavit to such criminal antecedent relating to the status of those cases. Yes.
My lord, I may be one more prayer, my lord. Court name is I inadvertently write in sessions judge, my lord, that is additional sessions. I may be permitted to correct.
The learned counsel for the petitioner submits that in the cause title of the bail application, the name of the court has been wrongly mentioned as Session Judge Jharsuguda instead of
Additional sessions.
Additional Session Judge Jharsuguda.
My lord.
And she may be permitted to correct the same. Permission is granted from the online file. So you file that first page, that type copy, because it cannot be. It's an online. So once you file a type copy of that first page, that can be.
My lord, in course of the day.
Yes, you file.
Yes.
Disclosure.
Disclosure. Yes.
Item number 52.
May I please?
Is to file the phrase cause title, corrected cause title. Yeah.
May I please, madam?
Yeah.
Madam, offense 20B 2C 25 NDP Act, madam. And madam, custody since madam 13/1/2021, madam. 13/1/2021, madam.
2001.
What order was passed in your last bail application?
My lord, 22/3/2024, my lord. Sorry, 13/2/2023, my lord.
Yeah. So there was a direction to conclude the trial
within 6
months from the date of framing of the charge.
My lord.
What is the position now?
My lord, so out of 17 witnesses, 12 witnesses already examined, my lord.
So, when the charge was framed, and you are a man from Kerala.
Kerala, man.
So, have you obtained about the correctness of the address furnished in the cause title?
No, my direction was made to produce the custody certificate last time.
No, that is that you produce, it's all right. But also obtain that instruction. The learned counsel for the petitioner submits that though in the last bail application filed by the petitioner in BLAPL number 3507 of 2022, while disposing of the same as per order dated 13 to 2023, the Ilan trial court was directed to conclude the trial within a period of 6 months from the date of framing of the charge. But as on date, out of 70 charge sheet witnesses, only 12 witnesses have been examined. Stop. Land counsel for the state has produced the custody certificate which is taken on record, and he submits that the petitioner is a man from Kannur district in the state of Kerala, and he may be given some time to verify whether the address furnished is correct or not. But the usual order for the matter to be listed, give a date. Yes. Address verification.
Well, custody certificate I have given.
That is taken on record.
Item 53.
53, my lord, petitioner is in custody under the NDPS Act, my lord, on 28/3/2020, my lord. 4 years, 5 months almost. Here, my lord.
28/3/2020.
2020.
And the status report indicates out of 25, 9 witnesses
Nine
have been.
witnesses from last November 2023 that was there. And your lordship last bail action is rejected in 25 के 2021 with a
No, when you are granted interim bail.
twice, my lord, twice. Last order, lordship may see, lordship call for a report from the Lord Session Judge, my lord. That is in flag V, my lord. Flag V. That is flag.
No, that has come. That indicates that out of 25,
that is
9 have been examined.
Yes. And only during his interim release, whether he has been misused and liberty.
That report has to be furnished by the State Council. Yes,
I pray for next week, madam.
Already.
Next week.
Madam.
All right. The Land and Council for the appear the status report submitted by the Land and Trial Court. Stop. Land and Council for the state seeks for an adjournment till next week to obtain instruction as per the order dated 9/4/2024. Put up this matter on 9th of August 2024. Yes.
Copy out a free copy नहीं है.
Number 55.
Please, Your Lordship.
Yes.
Your Lordship, in the order dated 23/4/2024, Your Lordship has called for the status report of the Land and Trial Court. And the petitioner is custody since.
Just a minute. Let me see the status report. So the start at 15, 14 witnesses have already been examined, including the victim. So where is the deposition copies?
I'll say, madam.
Have you got the copies?
Yes, madam.
Then have you supplied to the State Council? 376.3 is there.
The notice served,
submission.
madam, but the date
When notice was served?
It is served probably, when notice served, the CD has come on 11/4/2020.
Okay.
Along with it. Date has not been served, but served.
No, it's all right. So whether you are able to produce the deposition copies, particularly of the victim.
Yes, madam.
So victim has been examined as
PW5.
PW5.
PW5. So where is the deposition copy? Court file करना थी.
Small madam.
Yeah. This is not the deposition copy, Land and Council. It is 164 CRPC statement. You must know that what is the difference between a 164 and a deposition copy in court. Have you got the deposition copy?
I'm sorry, madam. Just.
The trial court has given the report wherein it is stated that 14 witnesses have been examined, including the victim. So whether it is available with you or not, if you are not having, I can call for, or you will produce the same. Victim has been examined as PW6.
Rejection order shows PW5.
Victim. नहीं इतने PW5 होगी father of the victim. PW6 होगी victim.
Yes, madam. PW6.
So, Mr. Tripathi, it is not a case under 376(3). How can it be 376(3)? The victim has not stated that any rape was committed on her. It stated that tried to commit sexual assault on me. That's all. When I protested, the accused pushed my wearing frock, threatened to take my life. Have you got the deposition copy?
No, ma'am.
Are you not supplying the deposition copies? Please see the deposition.
Medical he denied, she denied.
No, please see the evidence. How can it be a case under 376(3)? The definition which is there under 375, as per that amendment, it has to be complied with. So, how you say that somebody is pushed? Just then how can it be 376(3)?
I will level the
Has she stated anything to attract the ingredients of the no?
I will level
That's different. Are the learned counsel for the petition file the deposition copy? The learned counsel for the state. The learned counsel for the petitioner submits that the petitioner is in judicial custody since kebe ochandi?
4/7/2020, madam.
4/7/2020.
Yes, madam.
When we approved this court last time for bail in BLAPL number 4371 of 2022, as per order dated 26/10/2022, while rejecting the bail application, direction was given to the trial court to conclude the trial within a period of 2 months of recording of the accused statement. Since the trial court in the report indicated that the case was, the trial was at the stage of examination of the investigating officer. However, the status report furnished by the London trial court indicates that the case is posted today. The case is posted now for further cross-examination of some witnesses, so also examination of other prosecution witnesses. The London counsel for the petitioner placed the evidence of the victim who has been examined as PW6 and argued that on a plain reading of the evidence of the victim, the ingredients of the offense under section 376(3) of the Indian Penal Code are not attracted, nor are the ingredients of the offense under section 4 of the POCSO Act. And the 4 of the POCSO Act. Offense, other offenses like 354A, 354B are attracted, considering the submission made by the land counsel for the respective party, nature of evidence adduced so far, in the trial court, particularly the evidence of the victim, and for the taking into account the period of detention of the petition posted, and shall not indulge in any criminal activities, violation of any terms and conditions, shall entail cancellation of bail allowed.
My lord, my name may be mentioned, my Sadanam Bag.
Please give it in a state.
Grateful to lordship.
Item number 57.
May I please your lordship? Here, my lord, the petitioner is facing trial and being charged seated under section
Sorry to
450.
interrupt, my lord. Here, 3 witnesses are important. They are PW 5, 7, 8, and 11. I have the full copy of PW 5 and 8, but I do not have full copy
I
of
have
PW.
given already, my lord.
That
I have
has
filed the
given to
certified
us,
copy, lord,
but that
court,
is
my lord.
not complete. That is
And my
well
lord,
clear.
5th March, I have filed the entire.
Mr. Das, what he says that the
PW
position
7
copy
only
of
one
2
page.
witnesses are not complete. So why
PW 11
while
is
giving
not.
you part of the you should give it the complete deposition copy. PW के को साकी को
PW 7 and PW 11.
अच्छी अपन
PW 11 is the father.
आज अधा कहीं दे लेता हूँ
PW 7 is one of the friends.
से अधारे अपन को नारे कोई चीज़ हाँ दिल
No, my
नहीं
lord.
कहीं
Wrongly, it has not been. I'm just.
The learned counsel for the state submitted that
I'm just giving.
incomplete deposition copy of some witnesses have been given to him by the learned counsel for the petitioner, and they may be supplied with the complete deposition copies. The learned counsel for the petitioner submits that during course of the day.
In course of the day.
In course of the day, will supply the copies to the state council. Put up this matter on 9th August 2024. Yes.
Item number 64.
May I please your lordship?
Yeah.
My lord, bail application of the petitioner was earlier rejected by my lord by order dated 21st July 2023, and it was targeted and the loan.
Both BLAPL number?
My lord, BLAPL number 4676 of 2022. And my lord was pleased to direct the loan and trial court to dispose.
To complete it by end of December 23.
My lord.
So what has happened?
My lord,
Status report has come.
My lord.
Status report indicates that out of 32 charge sheet witnesses, 12 witnesses have been examined.
My lord.
So you have supplied the deposition copies.
My lord. By the time I filed before your lordship bail application, by then 9 witnesses were examined. I have filed the evidence of 9 witnesses.
No, 3 more witnesses have been examined.
Examined in the meantime, after my filing, my lord.
So why don't you give those 3 witnesses so that it can be taken up next week?
My lord, the 3 witnesses have not implicated the present petition.
How can the court know? How can he know? Are you having those copies with you? Why don't you give a copy? He may verify it just now if you are having the certified copy.
Certified.
If
present
CD is not also.
CD is not
also.
Present petition के कोई ना देखिए.
आगुर है नहीं.
All right. Wait, first time or thing?
आगुर level status report
was called for.
Status report has been.
But CDC was not called.
The learned counsel for the petitioner has handed over the deposition copy of the witnesses to the learned counsel for the state. Status report has been received. Learned counsel for the state submit that he is yet to receive the case diary and also the instruction regarding criminal antecedent, if any, against the petitioner. Put up this matter. Who thanar asiwa?
My lord.
Nandipoda
PS.
Who jila?
Andopur, Kendujhar.
नहीं सुना थी next week.
Nandipoda.
Anandapur तो होगा. Put up this matter on 9th of August 2020. Yes.
Oblige me.
Number 66.
66 में
Yeah.
Here, my lord, charge sheet has been here. My lord, petitioner is the brother-in-law of the my lord, that deceased, my lord. Charge sheet has been filed.
Wait, is it your first application or only?
My first application.
Okay. So just a minute.
I am arrested on the strength of the warrant, my lord, letter.
This is BLAPL 1812/2024. Runa Naik. So, এটা রুনা নায়ক মানে কোর্টে নিয়েছি ওটা? আচ্ছা।
The brother-in-law of the deceased.
আচ্ছা। What is the date of custody?
Custody is 22/1/2024.
And you have been charge sheeted under section?
Under section 498A, 304B and 34 of IPC, my lord.
You are the brother-in-law মানে কোন dear না দেড়শো?
Dear. And the husband.
What is the name of the deceased?
Deceased, my lord.
Shilavati.
Shilavati Naik.
Lilavati.
Shilavati Uthana Singh.
Shilavati
Uthana Singh.
Uthan Singh. Okay. So when the marriage was solemnized?
Marriage was solemnized 5 months before the occurrence, my lord. That is, occurrence was 3/1/2014, and as per the FIR, आज को 5 मास तले मो झियो टिटिमा मुन्ना नायक सहित बाहा होइतिला.
3/1/2014.
3/1/2014 is the date of the occurrence.
So you are an absconder or what?
Absconder, my lord.
So what happened to the other accused persons?
Other accused persons, their bail was granted, arrested and bail was granted, and their matter was splitted up. And trial has going. Its trial has completed, and they are acquitted, my lord. I have filed the judgment copy. FIR charge.
No, what about the husband?
Husband also acquitted, my lord. The judgment copy I have filed before your lordship, and also I have supplied.
Let me see that. That is that sessions trial number 68 of 2014.
14, my lord. Didima Naik is the husband. Didima Naik, accused number 1, is the husband. Henny Naik is the sister-in-law.
They have been acquitted.
Acquitted, my lord.
Right. Yes, Mr. Tripathi. Yes, heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner is the brother-in-law of the deceased Shilavati Uthan Singh and is in judicial custody since 22/1/2024, and he has been charge sheeted under section 498A 304B by 34 of the Indian Penal Code. The occurrence in question took place on 3/1/2014, and the marriage between the deceased and the brother of the petitioner was solemnized 5 months prior to the date of occurrence. He further submits that the husband of the deceased, namely
Didima
alias Munna Naik, and sister-in-law of the deceased, Henny alias Hemi Naik, faced trial in connection with the crime before the learned Session Judge Kandamal Fulbani in Sessions Trial number 68 of 2014, and by judgment and order dated 22/6/2017, they have been acquitted of all the charges. He has filed the judgment copy. Learned counsel for the state opposed the prayer for bail mainly on the ground that the petitioner was an absconder. Considering the submission made by the learned counsel for the respective parties, the nature of accusation against the petitioner, period of detention in judicial custody, and since the co-accused persons have already been acquitted in the trial court, I am inclined to release the petitioner on bail allowed.
Obliged.
Item number 69.
Yes, please, my lord. My lord, the prisoner is in custody since 31/7/2018.
2023 to expedite the trial and to examine the victim at the first instance. In the meantime, out of total 24 charge sheet witnesses, 7 witnesses have been examined, including the PW and her parents. I have supplied copy of the deposition to the state as well as your lordship, my lord.
No, the status report was called for, and the status report indicates that you are Vishwajit Pradhan.
Yes, my lord.
So you are in custody since
4/10/2022.
Right. So now it is mentioned in that report that out of 24, 9 witnesses have been examined.
Yes.
So what these 9 witnesses have stated against you?
No, so far PW1 is the victim. Last time I have supplied the copy of the deposition.
Deposition.
Yes,
and deposition copy
with the copy to the state, my lord.
Copy state को दीजिए. Oh, Mr. Das. कौन से victim कौन? Victim supported deposition. देखिए deposition copy टा दियो. आगे.
May I place it? May I place it? May I place it? Let yours.
Why don't you file the deposition copy?
देइछे कोर्ट देइ स्टेट को देइछे copy.
एठी नाही तो deposition copy को record अछि. नहीं मना करछे भी नाही. All right, let us see that. Victim is 24 years.
Yes, my lord. Both are hails from same village.
Wait.
Yes, sir.
Took place on so was Kolosha Yatra, returning on watching Kolosha Yatra. He gave me offer to sit on the motorcycle. এটা করলো আর্টিস্ট ভেরিফিকেশন যাইতলা না অমন এটা কি উত্তম ওটা কি এটা কোন নট করে কারা আসলে না উত্তম এটা কেভাবে রিপোর্ট 4/12 23 না এটিও রিপোর্ট আসছে 24 হ্যাঁ বা উত্তম না করেক্ট from the employee forum ಮತ್ತೆ ಒಂದು ಪಡೆಯುತ್ತೆ ಸ್ವತಂತ್ರ ಫಾರ್ಮಲ್ ಅಡ್ರೆಸ್ ಇಟ್ಟಿಗೆ ಇಟ್ಟು ಹಾ employee ಸೈನ್ করবে এটা হ্যাঁ এটা এই সেশনটা আসলে আমি এটা
Yes, lots of city that para 9 of the cross again.
It has not another is correct. It is for the son to be up. I get it. Yeah, fine. Right, are the Learning Council for the petitioner and council for the state. The Learning Council for the petitioner submitted that the petitioner is in judicial custody since 4/10/2022. Yes, and he has been charge sheeted under section 376(2) and 506(120)(b) of the Indian Penal Code. And in the meantime, victim has already been examined in the trial court, and at this stage there is no chance of tampering with the evidence. Therefore, the bail application may be favorably considered. Learned counsel for the state plays the evidence of the victim, bracket like then the PW1, considering the submission, nature of evidence at least in the trial court and period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail allowed.
Obliged.
Better they give them.
Item 91.
Last occasion, Lordship called for the CD and CA report of the petitioners, my lord. CD and CA report of the
Asila and next week. State Council and State Council submit that the matter may be taken up next week to comply the order dated 28/6/2024. This matter on 9th August 2024. Yes.
Item 100.
Yes, Mr. Das, Sogar Das, and K. Mahanti.
On behalf of Mr. Das.
Yeah.
May I please? Offenses 376 DA, 294 and 506 of IPC rate.
76 DA.
My lord.
So notice sufficient.
No, face matter.
Oh, face matter. Since one of the offenses under section so notice we issued extra copy. Usual order matter to be listed on 16th of August 2024. Yes.
One IA for
For?
interim bail on the ground of mother's illness.
IA number so this is an application for interim bail on the ground of ailment of the mother of the petitioner. Some medical documents have been annexed. You have received the copy?
Madam.
State Council has received the copy. Instruction be obtained. It is this matter.
I'm inside the custody in about 6 years.
Okay. Let me be today the first date and that offense requires a notice to the other side. So yes.
Item 101.
Yes, Mr.
Not for accused. Custody since 25/9/2019. Yes, sir.
Okay, status report indicates out of 23 charge sheet witnesses, 4 witnesses. What is the offense here? 302.
My lord. Similar situation, one of the co-accused has been released on bail.
It's a case of dacoity or robbery with murder.
Robbery with murder.
What about you have been named or identified in the TFI?
No. Only,
FIR is against unknown person.
No.
Then?
Only confessional statement.
ଆଉ କିଛି ନାହିଁ?
ନାହିଁ ଆଉ କିଛି ନାହିଁ. Principal accused ଅଜୟ କୁମାର ସାହୁ ସେ ବି ଇଣ୍ଟରଭ୍ୟୁରେ ଯାଇଛି.
You have received the case diary?
Yes, sir. The history sheet nurses. 11 criminal antecedents are also.
Have you filed the comprehensive affidavit?
No, this is the first.
Second application.
Get those numbers from the Land and State Council and file a comprehensive affidavit. You have got 11 cases against you. The Land and Council for the state has produced written instructions received from so and so, which indicate that the petitioner has got 11 numbers of criminal antecedents. The Land Council for the petitioner seeks some time to obtain instruction relating to the status of those cases and file a comprehensive affidavit accordingly. This matter 16 तारीख रख दें 16/8/2000. Yes, next.
Item 111.
कितने नंबर?
111 my lord. My lord, address verification ପାଇଁ
ଯାଇଥିଲା? Around case of conviction.
Yes, madam. Right.
You are a man from which?
One.
Acha, Faridabad in the state of Haryana. Okay.
Yes.
So, Superintendent of Excise Ganjam shall communicate with so and so. Yes, Mr. Tripathi.
Yes, Lord.
On address verification report.
First, he has given the address of Uttam Upadhyay. That is wrong address. That is correct. And secondly, second address that is correct. The correct address is Uttam Upadhyay, son of late Dilip Upadhyay, Mohabbat Orissa, PS Rivili, Ganja, district Saran, state of Bihar.
हाँ सेटा चला से एड्रेस पर ये लोग सिक्योरिटी दियो तो
सर
ସେ address ଟା ଦେଇ ଦିଅନ୍ତୁ ଯୋଉଟା correct ବୋଲି ତାର copy
ଆଉ
ଗୋଟେ ଦିଅନ୍ତୁ।
ଆଉ ଜଣଙ୍କର ଅନବରର
ନାଇଁ ସେ ଏଇଟା କଣ ଦି ଜଣ ପାଇଁ
ଦି
ଦେଇଛନ୍ତି?
ଜଣ ଅଛନ୍ତି।
ନାଇଁ ଆପଣ ବେଲ୍ ଦି ଜଣ ପାଇଁ ଫାଇଲ୍ କରିଛନ୍ତି? ଆଚ୍ଛା ଆରଟାରେ କଣ ହେଲା?
ଅନବର is correct.
Acha. The Learned Council for the state has already obtained instruction regarding address verification of both the appellants, which is taken on record. है ना? Let the Learned Council for the petitioner furnish names, address, and documents of two local sureties. You are furnished in court today. Furnished one. So Learned Council for the state takes some time to verify the same. Put up this matter on 16th August 2024. है ना? Published.
Item 113.
इसका आने की रखी है. It has address verification report. Yes.
Please, my lord. My lord, here the appellant is also convicted under section 307 IPC and sentenced to undergo the imprisonment for 10 years.
Yes.
Convicted under section 307 IPC, also sentenced to undergo the imprisonment for 10 years with fine. Whereas the similar footing co-accused has already been granted bail by my lord, and the incident of 2019.
Who has been granted bail?
My lord also granted bail. That is Shashidhar Mahaling also granted bail.
No, in this criminal appeal? Or?
Yes, same appeal.
What is the order dated?
It is my lord.
28/3/2023.
28/3/2023.
Yes, sir. 23 to 23.
But the main assailant is the present petition.
No, he was granted bail during trial. But the person who was granted bail by my lord, he was not granted bail. But
just a minute.
Sir.
Petitioner submitted appellant number 1, Shashidhar, was taken into judicial custody on 21/2019 and he was never released on bail and undergone sentence of so okay. And so far as appellant number 2, Suru, is concerned, he was released on bail and nature of evidence adduced by two injured persons, 6 and 7, and doctors PW 15 and 16. Okay. Then State Council placed the doctor's evidence PW 15 examined so there is amputation of lower leg 1/3 portion and the injury has been opined to be grievous. PW 6 has specifically stated that appellant number 2 assaulted him by means of tangia and severed his left leg, whereas appellant number 1 was present at this spot, left with severed leg. Therefore, so appellant number 1's overtact is he was just standing there and left the place with that leg. So, but so far as 2 is concerned, Suru Mahaling, the manner in which he assaulted PW6, severed his leg, that is the reason and the nature of injury that has been sustained. His bail application was rejected. So, what is the allegation so far as you are concerned? Because the two injured persons are
similar allegation.
PW6 and PW7.
PW6 is injured. PW6 is injured.
Injured ଅଛନ୍ତି PW6 ଆଉ PW7.
6 is the daughter and the 6 is the son-in-law.
हाँ आपनको मारले काहाକୁ ए जो petitioner
6.
What is the name of this?
Dandia, Swarup Dandia.
IA number 700.
Swarup Dandia.
Swarup Mahaling कौन लिखा है जी?
No, sir, Mahaling is the appellant. The different. Swarup Dandia is the injured. Surubabu Mahaling.
No, अपन bail file करଛନ୍ତି
Surubabu Mahaling. Mahaling.
Surubabu Mahaling. Right?
Alias Mahalik.
तानार कौन आश्ची evidence PW6 आओ देखी deposition copy देखी Surubabu नारे trial court record भागो PW6 और PW7
Para 21 of the
Accused Suru assaulted my wife by means of a medha, for which my wife sustained injury on the left hand and head. Then accused Suru also assaulted me mercilessly when I tried to rescue my wife. I was assaulted at the thrashing floor of Chakradhar. I fell down on the said thrashing floor when medha blow fell on my head. Then Suru Mahalik completely severed my left leg by using tangia. And after that, accused Sasi Mahalik left the spot along with the severe leg towards Sulia forest.
Sasi Mahalik at a bail.
So that is the evidence of PW6.
Sir.
And PW7 is the wife of PW6.
The daughter
And
also, is the daughter of
daughter.
Yes.
She has stated that
Same thing.
Surumali came armed with one thenga, then started abusing me so and so. Then he tried to assault me with assaulted me by means of thenga gala. I also sustained injury. So when my husband came there, daughter of the god, PW6 was
Husband 6 is the husband of PW5.
On that day, Suru has brought one tangia with him. He brought out the tangia by declaring that he will kill Saurav. The accused person chased to assault soon. I was following them on. Suru Mahalik assaulted my husband by means of meda at the thrashing floor of Chakradhar. My husband became senseless. So it is you who gave the tangia blow and severed
The para 22 of the judgment, that is stated, there is consistency in evidence of PW6 and 7, the injured persons, and this case that on the relevant date and time of incident, the accused Shuru Mahalik, Shashidhar Mahalik, and the Ganeshwar Mahalik started quarrel with the PW7 at Anganwadi center of their village, and when the PW6 intervened and came into rescue of his wife, the accused persons, namely Surubabu Mahalik and Shashidhar Mahalik, assaulted the injured on the thrashing floor of the Chakrathar Mahalik. On the assault by means of the medha on his head, he fell down on the floor, and thereafter the accused Suru Mahalik chopped off his leg by means of tangia, and accused Shashidhar Mahalik ran away with the chopped off leg towards the Surya forest.
So you are the person who
no, the person who has also taken away that leg is Shashidhar Mahalik has granted bail.
Are the learned counsel for the petitioner and counsel for the state in view of the overact attributed against the petitioner and the manner in which the petitioner has assaulted the injured bracket PW PW 6 PW 6 and severed his leg. I'm not inclined to release the petitioner on bail. The petitioner is at liberty to renew the prayer for bail if after undergoing half of the substantive sentence, the case is not taken up for hearing. Yes.
Item 114.
114, Lordship. This is a criminal appeal, but in nature of bail, my lord. SC is there, my lord. The present
delay is there or what?
Yes, my lord. I is my report.
But there is no delay pointed out by the stamp reporter. So it is to be disposed of. 114 na?
114.
IN number 238 of 2024. This is an application for condonation of delay. Since the stamp reporter has pointed out that there is no delay in filing this CRLA, this interim application is disposed of. Okay. Now, this CRLA has been filed for what? Bail.
Bail, my lord. Nature of bail.
It is 360 Act.
Yes.
Notice has been issued.
No.
No, it has not been.
This is the, my lord, fifth consecutive application, my lord.
So fifth consecutive notice jiboni SC matter. So let an extra copy of this one so be served on the line. Baki usual order for the 16 तारीख
Great.
Item 120.
May I please? Here in this case, my lord, appellant was arrested, taken.
120. Yes, Mr. Sahoo.
Appellant was in custody since 2/1/2023.
Yes, just a minute.
Let the CD come.
এটা কোন HCST matter?
Yes, ma'am.
Notice.
No, notice was first time.
No,
second time. Notice was issued earlier order, your lordship kindly. Right.
Wait.
Order.
No, କିଛି order ହେଇନି. Extra copy.
The order is there.
Respondent number 2. ଆପଣ ଦେଇଥିଲେ extra?
ଆଜ୍ଞା। ନାଇଁ କିଛି ନାହିଁ, first time already I have filed, my lord.
ଆଚ୍ଛା, ଆଉ ଦେଖନ୍ତୁ କଣ ତାକୁ ଡେରି ହବ, ନହେଲେ ଆଉ ଖଣ୍ଡେ ଯେ ଦବା କଥା ଦେଇଦିଅନ୍ତୁ, ନହେଲେ ପୁଣି 4 ଥର ସେଇଆ କହିବେ. The Learned Counsel for the state submitted that he is yet to receive extra copy of the application from the Learned Counsel for the state from petitioner as per the order dated so and so. So put up this matter on such and such date. Notice be served in the meantime on this so and so. But considers it out IA for so and so for condonation of delay. Either notice. Okay. Yes.
No, delay was condoned. Delay was condoned.
Who said to you that delay was condoned? Who ordered it? Delay has not been condoned. Notice has been issued for condoning the delay and also, of course, for hearing the matter on merit. So, yes.
Lordship, keep it.
16 तारीख दिन.
Full.
ତାଙ୍କୁ ଆଉ ଖଣ୍ଡେ ଦେଇ ଦିଅନ୍ତୁ.
By Monday I will submit.
Yes.
Item 74, my lord.
ये मेंशन सरीगला. ये केते नंबर आपनकर? 74 कोन आनी छन दिसे? अछि तो? ओके.
My lord.
Just a minute.
My lord.
Yes, 21 CNDPS Act.
Minor. Petition in custody, minor. On 2/11/2020 petition in custody, minor. 2/11/2020 petition in custody, minor.
When you approached this court last time?
Minor, last time I approached this court in BLP number 7590/2023, in which your lordship granted 3 months interim bail and petition in surrender in the right time. The annex 2 is the surrender certificate, minor. And
so whether there is any allegation of violation of liberty, that was the order passed about the conduct.
Sir.
5th July orders. You have the co-constitutional person released on bail by your lordship's order, my lord.
No. Bartaman position kono?
My lord, in the meantime, my lord, out of 38 witnesses, my lord, 37 witnesses, 11 witnesses are examined. And
total witness संख्या होची 37.
My lord.
11 ता साक्षी ही चंदी.
My lord. So, and the you have the co-constitutional released on bail by your lordship's order. Same.
So how many times you are released on interim bail?
My lord, 3 times released on interim bail. I lord surrender in the right time. No.
Last time in this.
In 3. Last time, my lord, 7590/23.
Are the Learned Counsel for the petitioner, Learned Counsel for the state. The Learned Counsel for the petitioner submitted that the petitioner has been granted interim bail thrice, and after availing the interim bail period on the ground of delayed disposal of the trial, and after availing the interim bail period, he has surrendered at right time. As per order number 1 dated 5/7/2024, the Land Council for the state was asked to obtain instruction whether there is any allegation of misutilization of liberty regarding the conduct of the petitioner while on interim bail. Today, the Land Council for the state has produced the written instruction received from IIC Sadar Police Station, Puri, dated 25/7/2024, which indicates that during the interim bail period, he has not committed any offense. The instruction is taken on record. Land Counsel for the petitioner submitted that out of 37 charge sheet witnesses, 11 witnesses have been examined so far. Considering the submission, period of detention in judicial custody, since the petitioner has not flouted the terms and conditions of the interim bail order, 3 months bail granted. Yes, next, disposed of.
Lordship, item number 72.
72. No.
Why
did you make a mention early, Mr. in the first hour? They are
Last
not with the file with them.
In the earlier occasion, last order, bar 7/24, the State Council seeks adjournment to file his.
The council just make a mention in the first hour if you want that it is to be taken out of turn, so that the State Council will bring the file, because they are not having that item number 72 file with them that I was asking to the State Council. So it will, all these matters will come on 9th August. So if any urgency is there, you can make a mention in the first hour so that it can be taken off at 2 o'clock. Okay. So rest of the matter will come next week.
Yes.
There is a item number in 41. There is a interim order is there.
Anticipatory bail.
Anticipatory.
So that is to be extended to.
My lord.
My lord, item number 43 also an interim order is there.
That will just give a list so that.
My lord.
41 42.